I'm aiming for this session to take approximately half an hour, hoping to fit in a bit of time for questions at the end. So, yeah, if you've got any, I'm happy to stay on if it runs to half past and you've got questions. But what's it all about, first of all? So I'm going to be focusing upon one of what I class as one of the most significant changes ahead of the Employment Rights Act changes, which is the right to claim unfair dismissal after 6 months. So currently it's at 2 years. I'm going to look at what makes dismissal fair or unfair. I'm going to look at the 5 types of fair dismissal. And I'm going to talk about what 3 actions I think all employers should be taking to prepare for that new right, and what else those actions will do to benefit you as an employer. So without further ado, I'm going to attempt to share my slides and crack on. Where are we? Can you see slides?
Yeah.
That's it. Right, lovely. So yeah, so for anyone who doesn't know me, I think most of you do. I'm Yvette. I'm the founder of Beanstalk HR, which is an HR consultancy that I've been running for about 3 years now. I'm absolutely passionate about all things people, particularly facilitating better people management and leadership, and that for the benefit of employers and employees. Obviously, I've been both, seen both sides of the tale, if you like, and yeah, want to make things better. I've got over 20 years in HR and over 30 years experience in people management, so I've kind of done my time. I'm qualified level 7 CIPD, and I'm also an ACAS accredited mediator, and I am a Clarity 4D partner. So that's psychometric profiling and all the associated work that goes with that, which is good fun. Firstly, I want to kind of bust a bit of a myth. So it's a common misconception that you can just dismiss any employee before they've got 2 years service, and that it's risk free, they can't bring a claim. So, under 2 years, let's just not bother with processes. Happens to be kind of the attitude sometimes. But there are actually loads of types of claims that employees can make from day one. So we'll just look at a few. And the big ones are discrimination. So any of, these kinds of discrimination, if you are subject to that as an employee, you can make a claim from day one. In particular, there is, more law enforcement, stricter laws coming around sexual harassment and the things that you should be doing to prevent that in your workplace. So again, it's the proactive stuff that helps to mitigate that risk. Wrongful dismissal is day one right as well, and that's slightly different to unfair dismissal. It's about a breach of contract within the dismissal. So, for example, if you don't pay someone their notice pay, they can take you to a claim for wrongful dismissal. Anything around wages and working time, that's all day one. Tube pay, so if you don't consult properly. And then we've got this huge list, won't fit on here, of automatic unfair dismissal reasons, which are all applicable from day one. So if you make a flexible working request and you can show that you've been dismissed for making that request, then you are entitled to bring a claim under automatic unfair dismissal from day one. And of course, people now have that right from day one to request flexible working. So that's another one to be aware of. But any kind of trying to exercise your statutory rights as an employee, if you are dismissed because of that, doing jury service, whistleblowing, raising health and safety issues. If you do any of that as an employee and are dismissed for that, and again, the employer would have to show that that was the reason for dismissal, then there's potentially an automatic unfair dismissal claim. But it's true that currently an employee with under 2 years service can't claim unfair or constructive dismissal, the ordinary type. As we've seen, there's loads of other types that can apply if we don't treat people fairly as a matter of practice. So always good to get your practices in order. Right now, if an employee has 2 years service and they claim unfair or constructive dismissal, then they will succeed if any of the following apply. So, no fair reason for the dismissal. The reason was not enough to justify dismissing them, or the employer did not follow a fair procedure. And that might be going back to the procedures that preceded the dismissal. So, if you've given warnings and they weren't fair, and that's all been built on. So, even if a claim isn't successful, the process can be really stressful. It'll cost you thousands probably in legal fees. So best avoided if at all possible. Now, constructive dismissal, which is classed under the umbrella of unfair dismissal, is where an employee resigns themselves because they feel that you have seriously breached your employment contract, the two-way contract that you have with them. So things like failing to, generally look after their welfare, if they're being bullied or, bring some kind of grievance and you don't act on it, then they could resign and claim unfair dismissal, constructive unfair dismissal. So, in terms of what's classed as fair, you'll hear a lot about fairness and reasonableness in employment law. And when you're making a dismissal, both must be present to avoid those claims. Now, what is fair and reasonable, you wouldn't really find out until you got to a tribunal. So, it's better to try and follow these steps and do your best to mitigate any risk. So, tribunals are looking for a valid reason, which I will go into what these are in a moment. They're looking for procedural fairness, proper investigations, following that ACAS code, making sure that people have a right to be accompanied, a right to appeal, etc. And then there's what they term reasonableness. So there's not a legal definition, and the tribunal makes its own assessment and would compare, what would a reasonable employer have done in that same situation. So that's whether you've got a genuine belief that the reason for dismissal was valid. Was it a proportional response? Is it consistent with what you've done with past cases? Were you really clear with employees about what constitutes, a reason to dismiss? And did you look for support and alternatives, particularly if you're making an ill health dismissal? So I've got a couple of examples here of cases where the dismissal was found not to be fair. So in Hamilton versus Clean Event Services, a security supervisor was awarded nearly £30,000 for unfair dismissal. So what happened was the employee at some point was given a promotion, and as part of the promotion, someone authorised extra holidays and extra sick pay. Didn't put it in the new contract. He contacted HR, who said, write it in yourself. So he did. And then HR left and he became sick at one point, and then it came out that that he'd amended his own contract with these new benefits. Told them that the HR manager had said to do that, and they didn't ask. They didn't go back and find this HR manager and explore the possibility that actually he was telling the truth. So the tribunal found that the dismissal was unfair because they failed to conduct a fair investigation, crucially not getting that evidence from the former HR manager. Apparently there were also some key documents withheld in the process. And the judge said that no reasonable employer could have concluded the employee acted dishonestly based on the evidence available. So they said that the decision then fell outside of the band of reasonable responses. Yes, so even something that seems quite heinous like that, making your own contract up, potentially unfair to be dismissed. So yeah, £30,000, not a drop in the ocean, and with all the legal fees added on top, it's a lot. Then in Shah versus Food Hub, £60,000 over. We're talking about the remedy here. So Shah had been working for Food Hub for about 4 years when in 2022 he was accused of working remotely from Egypt without permission, which he disputed. He also had been asked to replace his company car and didn't in time. So then as a punishment for that, allegedly, he was asked to work 4 to 5 days a week in the field. That was a new requirement that was introduced to him and something that he'd never been expected to do. So when he didn't do it, the CEO accused him of stealing money and illegitimately taking a salary for failing to do his job properly and dismissed him for gross misconduct. No procedure or anything, just, yeah, out you go. So HR intervened and said, well, you can't really do that. And it was reinstated and a new disciplinary process run, at which point a manager that had only been with the company for, I think, 3 weeks found him to have committed this breach and dismissed him again. And the outcome of that was that the tribunal held the dismissal was unfair due to lack of process, predetermined decision making, and undue influence from senior leaders. So, what they said about this manager who was doing the disciplinary is that she was under too much pressure. She was a new employee herself and was under pressure to make that dismissal. So you can see, it's an expensive job and it's easy to fall foul. So we're going to talk about fair dismissal reasons now, and there are five of those. The first one, conduct. So if someone won't do something that you've asked, or more often they do something bad, do something you don't want them to do. Dismissal wouldn't usually occur after just one incident unless it's gross misconduct. You would have a series of warnings. So that's, investigation, hearing, warning, potentially appeal, investigation, hearing, warning, potentially appeal, investigation, hearing, warning, dismissal, sorry, potentially appeal. So there's a lot of steps in that, a lot of work to do it properly, unless it's gross misconduct, and then you would go straight to the final step. Capability is can't do, so it could be a skills or ability thing, and quite often it's an ill health thing. A person's just not well enough to do the job. So again, with capability, you would usually go through 3 steps, but with ill health, it might be slightly different, and you would be looking at things like getting medical advice, making adjustments if they are classed as disabled, and trying to help them to be back into work. So I would usually always say have, as well as a disciplinary policy, have a capability policy, and alongside that, have a sickness management policy. So redundancy, you don't need them to do the job anymore, no longer needed. Um, Again, it's a complex area, so I would always get advice if you're thinking of making redundant. Say there's lots of regulations around selection, consultation, and you've got to get it right. There's the legal reason. So if it's illegal for someone to now do the job that you need them to do, for example, a driver who loses their license, or it can be a safeguarding issue if you work in a sector where safeguarding is important and someone, I don't think the term is fails a DBS, but if things come to light that makes it illegal for them to do the job. Um, and then some other substantial reason, which is some reason why that person shouldn't stay in your business. Now, ACAS gives some examples of a fixed term contract ending, which is a really simple thing that happens a lot. You take someone on a fixed term contract, tell them when it's going to finish. They're not, it's not a case of conduct. They might not be redundant, but the term is ending. So you've got that substantial reason. ACAS gives these other reasons, third party pressure. So if your client won't work with your employee, or if an employee refuses to some new terms that you need to put in, and you've got to be careful around that, obviously, because, it's got to be reasonable. And then it's commonly used as well, where there's an irreparable breakdown in relationships. Now, when I say it's commonly used as that, it's kind of, for me, in my experience, it's been one of the most frequent things where it's come up, where SOSR has come up. Recently, I looked at one with a CEO who had just broken down trust with all of their managers under him. It was a charity, so the board of trustees were really, stuck really. They needed to remove him as soon as possible because of the damage to the organisation, the service users. It was potentially huge. But being voluntary, they'd not really had the time to manage the situation. They'd not followed any capability or conduct processes. And there was nothing standing out as one serious issue where we could go, okay, there's a gross misconduct issue, or, we need to dismiss for one of these other things. There was no redundancy situation. So we talked there about this breakdown in relationships, and I supported them to conduct a really thorough investigation, show the extent of the damaged relationships, and most importantly, the impact on the organisation. And then once they'd put all that together, fortunately, before they needed to even convene the hearing, the CEO agreed to a settlement, so it was settled outside of any processes. But the prep was there. They gathered their evidence. So make no mistake, if you want to use SOSR, you really do need to put together a solid case. Just going to have a little mouthful of water. So yeah, currently for normal unfair dismissal, employees need 2 years service. But from January 2027, they will only need 6 months service to claim. So anyone employed now onwards before July this year will then have the required length of service. In addition to that, in October 2026, the time limits to bring claims are going to be increased from 3 to 6 months. So instead of when you dismiss someone or when they leave because they feel like they've been pushed out the door, them having 3 months to bring the claim, they'll have 6 months, and that's extended as well with the ACAS conciliation period. So you need to, hold on to records and be quite clear that you've got the evidence you need for quite a while after that person's left. Um, the compensation cap as well for unfair dismissal is going to be abolished. Now, the kind of the reasons that compensation is given, so in unfair dismissal, it's to compensate for the lack of income. That reason is staying, so there won't be any kind of injury to feelings added to it or anything. And at the minute, the average is £14,000, which is well under the current gap, which I think is about 120 grand somewhere. But it's worth, thinking about in terms of if you've got employees who have like a substantial pension loss, if they're on this defined benefit pension, if you've got very high earners, or employees that could suffer, a career-ending loss if they're dismissed. You need to think about the impact of that and how that would push claims up. And it could also stop people from settling if they've, get a real unrealistic expectation of what they're going to be able to get. It might hinder that process. So I am suggesting that people take a three-pronged approach to preparing for this change. So firstly, you need to get a focus on effective hiring, onboarding and probation to reduce that risk of taking dismissals after 6 months, because if it's clearly not working out in the first 6 months, then end it while it's fairly safe to do so. Then make sure all your processes are in place and you're doing everything consistently, so that if you do make some dismissals after the 6 month period, then you can satisfy yourself that you've done that fairly. And then think about the fact that people can leave of their own accord and claim unfair dismissal and mitigate the risk of those constructive claims. So yeah, that's all about your proactive employee relations. And there are additional benefits to doing those things. So, that three-pronged approach, it's not just about doing it for, to protect yourself, but it leads to things like better hiring, better performance, culture. It helps the business to function better anyway. So just a few examples, in hiring and onboarding properly, I think, one of the standout things is that if you're carrying out a really good onboarding and probation period, then people are going to get competent faster and arguably they're going to get to a higher standard. So that's really important. Obviously, it's better for the business that you're more productive, more efficient. Ensuring that you make dismissals fairly. After that, again, making sure people are trusting the processes, being transparent, helping engagement, all those things that just building a trusting culture leads to. Particularly as well, not so much around the trust, but around improving those processes and kind of side effects of that. If you can manage absence better, that becomes really crucial as SSP becomes a day one right, which it is due to do in April. So day one as in from the start of employment, but also day one as in we won't have those 3 waiting days anymore or 4 waiting days. So as soon as someone's off, they'll be entitled to SSP. So you can imagine if you've got a lot of short-term absence, that's going to be a real cost. So getting on top of that is important. And then having, really effective employee relations processes in, making sure you've got a healthy workplace culture, higher engagement, which it's been shown, there's been lots of studies that show that higher engagement leads to better business results. So it's, an important thing to have, and building that trust and people believing that they're safe at work, and, if there is an issue that it'll be followed up. It might reduce your sick rates because people are less stressed, but all in all, great things to do anyway, despite, as well as mitigating these risks. So what kind of things can we do then? Um, I'm going to send these slides out anyway, and I am kind of running out of time, so I'll just quickly go over these. But it's all about using structure, using frameworks for when you're doing your hiring, your onboarding, making sure that's really thorough, giving people the right training, checking in, setting clear expectations about performance and behaviour, and doing that probationary period as you should, which is holding regular reviews, not just one at the end, documenting everything. So if you've got issues, documenting that, providing the right support, extending probation where it's appropriate, and make sure you make that decision. If it's going to be a dismissal, make sure you do it before the 6 month mark. And of course, training all your managers in these processes. So making post 6 months claims, we need to again make sure all our processes are right. They need to be aligned with ACAS code processes, which you can look up from under ACAS. Set clear expectations again, act promptly, record everything, write everything down. If you don't write it down, it didn't happen. Train your managers to follow these processes, let your employees know about issues promptly, don't stick your head in the sand, make sure things get dealt with early on. Follow all the ACAS steps, do, thorough investigations, be careful about using suspension. And yeah, ensure decisions are based on evidence, really. So make sure that you're following all those steps, the right to appeal, all those things that ACAS tell you should do. And then to mitigate risk of constructive dismissal, doing all those things that you need to do to protect your employees, looking at your policies around whistleblowing, grievances, harassment, etc., making sure that you're taking all the right steps to make sure people aren't bullied at work, for example. One thing that's good if there are relationship breakdowns is to use mediation. That can work on, like at an individual level, or it can be used, mediation techniques can be used in conflict management, and I do a lot of that sort of thing. So if you need to know more, get in touch, or if you want to know about any more services, get in touch. Um, but yeah, doing that, doing things right, just doing things with dignity and respect, and ensuring that people are invested in, really. So, like I say, I'm running out of time a little, but I have a couple of minutes left. I think if anybody's got any questions, and I can see there's one in the chat. I am happy to stay on longer, but I don't know if it's going to cut me off. Put my email address on there, so get in touch if you'd like to have the slides or the recording. If you want to do an HR essentials check for your organisation, this is the QR code there. It's a very short survey, 4 minutes, and then I'll give you some personalised feedback. If you want to follow me on LinkedIn, there's a code there. So just looking in the chat then, what have we got in here? I'll stop sharing my slides and see if I can see if there's a question in the chat. It's not showing one to me. No. Has anybody got any questions?
Can I ask one,
Of
Yvette?
course, yes, please.
You probably won't know the answer to this yet, but if you said the cap was going to be abolished for the
Yes.
unfair dismissal claims,
Yeah.
do you think it'll be on the person's salary, full salary, rather than sort of the redundancy cap that they'll work out the unfair dismissal amount from? Or is there anything out there at the moment to guide us?
Yeah, I'm not sure on that. Because obviously at the minute, in terms of the cap, it's a top cap plus
Mm,
the salary, isn't it? And I'm not sure if the salary one will still be in place. But it's a good question. I'll try and find out, and I'll add that when I send out the thing.
okay, thank you.
Okay.
I have a
And
question, if I could. You know,
yes,
you
of
were on about
course.
during the onboarding, holding
Yes.
formal probation reviews, not just at the end.
Yes.
I'm guilty of that. We just do it at the end. Now, I do give them sort of verbal feedback, but I'm
Mm.
not very good at sitting down and holding a formal probation review other than at the end, yeah, we were happy, or this is where you need to work at.
Mm.
So, have you got any ideas for that? How often we should do them and how formal should we be making a note, documenting what we've
Yeah.
discussed?
I mean, it's good that you're giving regular feedback, but I do think you should probably do something documented at least once a month.
Right.
But more, if there are issues, then what you want to be doing is setting expectations and revisiting it perhaps sooner than that. Do you know what I mean?
Yeah, I haven't. No, no, I haven't. I've just taken a new employee on. We haven't got issues, but I did give feedback, positive feedback yesterday, and it's just I haven't documented it,
Mm.
so it's just a once a month and documenting it. Um, we use your service, so do you have sort of a template I should follow for that
I do.
review?
I'm sure you've got one, Tony, but I shall wing it
Dig it
over.
out, please, if you would. Thank you very much.
I will.
That's not to say I don't read your documents. I just would certainly know what it is.
Yeah, I'm sure you've got one.
Thank you.
Thank you. Anybody else? I don't know if it's going to time us out because it's saying I need to upgrade to Pro, so it's
All
only
right.
giving me 5 minutes left according to the timer, but 5 minutes is good if anyone has any questions. Lovely.
Right.
Well, I'll call that a day then, and thank you all very much for attending. And yeah,
Thank
take
you.
care. Thanks very much.
Thank
Thank
you.
you.
Bye.
Bye. Bye. Bye, everybody.
Well, I better stop.